So for those who don't know me, my name is Serena Richardson, and I am an RSTP trainer, and I will be the moderator for this webinar today. I'm also joined by my colleague, Ghazal. She is an RSTP trainer located on the West Coast. She's my backup person in case anything goes wrong, and she'll be managing some of the technical responsibilities for me. I'm pleased to introduce our two panelists for this webinar. We have Gilbert, who is the Director of Refugee Ministries of the Roman Catholic Diocese of London Refugee Ministries Office, that includes Inland Protection of Refugees Program, so the program for refugee claimants, and Overseas Protection of Refugees. Gilbert is directly responsible for the latter program, and he brings years of experience as sponsorship agreement holder primary contact. Joining him is Tim Witchert, an immigration and refugee lawyer who specializes in refugee claims, appeals, and judicial reviews. Tim has helped many families and sponsors challenge refugee sponsorship refusals successfully. In the past, he was a refugee program coordinator for Mennonite Central Committee Canada, and he's currently based in Niagara. Together, they'll share practical lessons and successful stories to help sponsors feel more confident when facing a refusal. As private sponsors, we know how much time, energy, and heart goes into the sponsorship process. But sometimes, despite our best efforts, applications are refused. And this can feel discouraging and even overwhelming. Today's session is designed to give you the knowledge and tools to respond to these situations with confidence. We'll look at real case examples to understand common reasons for refusals, the role of procedural fairness, and some of the mistakes that can happen in the system. We'll also talk about what to keep in mind when working with a lawyer, and most importantly, we'll highlight success stories, showing how judicial review has helped many families find a positive outcome. By the end of this session, we hope you'll feel more prepared, better informed, and encouraged that refusals don't always mean the end of the road. There are real strategies, real lessons, and real successes to learn from. So let's begin hearing from a sponsor's perspective. Gilbert, can you tell us about your SAWS experience with refusals? What was the process that you followed?
The navigation of the process of judicial review has been gratifying experience. Although our SA strives to maximize the chances of success in every PSR case by submitting cases that are as likely successful as possible, we get a few refusals over the years. So what we do, we systematically encourage principal applicants via our co-sponsors to tell us what they believe the officer's concerns were at the interview. In the past, our SA has made a few reconsideration requests, what we used to call responding to a negative decision. But in our experience, IRCC will confirm the visa office's decision every time. I have heard some success recently from some SARs. Maybe to be honest, one SAR told me they had successful responding to a negative decision, but we have not had any success, even if that was a long time ago. And my SAR, for reasons I might explain later, maybe in question and answers, we are not intending to go back to this route. At the same time, we didn't have this chance of reversing any case by responding to a negative decision, or what we call now reconsideration request. We continued our ambition of challenging every refusal. In other words, we strive to make our visa offices aware that the negative decisions are looked at and can be challenged. In terms of the hurdles that are always in our work, we have moved from this responding to a negative decision or reconsideration request route, because not only we had no success, even in cases where we believe the officer's negative decision was wrong. But also, this route, we noticed that it was handicapping the judicial review option. It was just making a stop to this process. What we have experienced is that most of the time, refusals give no reasons for the refusal. And even if the refusal letter will give the main reason of the negative decision, you really need to request what we used to call KEPS notes, that is called today GCMS notes. And these are the transcripts of almost all what happened in the interview room. But to get those notes, it will take 90 days or more. An example I can give to you that is current is that we have made a request for these notes from the visa office, and the request was made on June 30th, but we have not received these notes yet. We are still waiting. So what is the problem? The problem with this responding to a negative decision or reconsideration request is that by the time you receive the notes describing the motivation of the negative decision, the 60 days timeline for your lawyer to file the judicial review in the federal court will have passed. In our experience, to have now the judicial review, which we take as the best route to not always be too late to act on a refusal, I want to share with you is that for a SAR to really help people is to have a solid relationship between them and a certain lawyer. And I would say a lawyer that is more than just an immigration lawyer, but to identify that kind of lawyer that is also a refugee advocate. Deciding to proceed with a judicial review or not. We know that the financial capacity is the number one that has to be checked. When we receive a refusal, the first thing our SAR will check with the co-sponsor if we can make it, if the financial capacity is there. And the next thing would be to send the refusal letter together with the schedules and, if possible, the entire IMM8 package to our lawyer. And as I said before, we will ask the principal applicant to put down to think and remember what he believes or she believes the reasons of the refusal are. Speaking of the financial capacity or the money that is required to make this happen, we need to have an effective management of the legal fees, and that is a part of our best experience because we have had an offer that was amazing to us. I have heard this from the co-sponsors that do this with us because our lawyer has given us a division of legal fees in 2 payments. And the first payment will be quite small. And this quite small payment will take the process of judicial review from the beginning where I started to the point where the lawyer receives the GCMS notes and review them and gives us an opinion and makes his comments. It's a great thing because when the lawyer's comments and the feelings of the principal applicant and the co-sponsor together, we decide to discontinue the judicial review process, the whole process will end without spending a lot of money. An example is a case where the co-sponsor, thanks to the lawyer's opinion and the comments, decided to not proceed after receiving the GCMS notes in 2019. We rather decided to reapply for that family. And the good news is that this family has been successful at the second interview and is expected to arrive in the next month. Now, when your lawyer has been successful with the federal court, you have to take this opportunity to not waste the decision of the federal court. That, as the lawyer will say this legally, but they cannot reverse the decision of the officer overseas. But we have the opportunity to have a second interview. To take advantage of the success of the judicial review, it is really to make sure that the second interview will be the best interview. And that is where we have also experienced the gratitude and what can come out of a good collaboration between a good lawyer and sponsors and the co-sponsors. Our success has been due to the lawyer's assistance in identifying the gaps in the first personal story. He will help identify and assist with the preparation of these affidavits. And these pieces will increase the chances of success at the second interview. We have experienced some unusual good things, including that in some cases, the lawyer will advocate for short timing for the second interview. And this was granted in some cases. That was really a good thing that has made the people we help and our SA very happy. I will say that to submit a strong submission depends on what I have said before, focusing the co-sponsor and the principal applicant on what happened before and what it was missing and can help. And a good collaboration between the SA and the lawyer, that is what can make a good new submission that will lead to success of the judicial review in the end. I would like to finish by sharing with you the success we have had, a recap of our cases from 2012 to today. The refusals we have received, we have made 31 cases of judicial review. And out of these 31 cases, 20 cases were successful. 6 cases were dismissed, 5 cases were discontinued. I expect the lawyer, from a legal point of view, will cover what it means for the federal court to dismiss a case, what it is. But to discontinue a case, a judicial review, it is what I have explained, that in some cases, where thanks to the lawyer's comments and opinion, the co-sponsor himself and together with the SA and the principal applicant, we might decide to discontinue the judicial review, to not proceed with the judicial review, and stop there and maybe reapply. Out of these successful cases, we are glad to share with you that 34 Canadians or permanent residents now are in Canada. They are safe and they greatly contribute to the new community. An example is a family of 6 that was successful through judicial review. They arrived in October 2023. I spoke to them just this last week, preparing for this. Both husband and wife are PSWs, and the husband will soon become a nurse. In less than 3 years, they are on the way of purchasing a home in the city of London, and their children are so smart, they're working so hard in school, and they will soon be aggressive as their parents are. I have asked the RSTP to put in the chat a written testimony of this family that is in Canada and is doing wonderfully, thanks to the judicial review process, thanks to a good collaboration between the SA and the lawyer, thanks to our belief in the judicial review procedure. I will stop here. Thank you very much.
Thank you so much, Gilbert. I am excited to see these numbers and to hear that success story, the one that you shared. Now let's hear from Tim. Tim, can you speak to the decision letter that IRCC sends out when IRCC refuses an application for permanent residence, and why judicial review might be a viable option for sponsors?
Sure. Thanks, Serena, and welcome everybody. Thanks for joining us on such a lovely day, at least here in Ontario. It's nice to see some familiar names as well. So the dreaded refusal letter. Let me mention 2 things. First of all, I'm sure most of you have received these, which is why you're here this evening. And if you were all to compare notes, you would realize that they basically all say the same thing. Few details, as Gilbert says, and what we find is the statements generally sound the same. Credibility concerns were noted at the interview, and your responses did not alleviate these concerns. Or, I am not satisfied that you have a well-founded fear of persecution. So that's the first thing, very few details. Second, it is impossible to assess a case and the chances of success on judicial review based only on the decision letter. There may be some clues So, for example, some visa offices have unique issues which are reflected in the decision letters. Many of you with cases in Pretoria, for example, South Africa, will know that many refusals there are based on durable solution. So the letters will often mention that. But there's no way we can properly assess a refusal decision without seeing the officer's underlying reasons and assessment. And these are never included in the decision letters. For example, why was the officer not satisfied that you did not have a well-founded fear of persecution? Or why were the responses you gave not sufficient to address the credibility concerns? We don't know that. For those, we need the GCMS notes, which Gilbert was talking about, or the interview notes. And one of the ways to get those is through judicial review process. The first step is to file a notice of application in federal court. When we file a judicial review, we will indicate that the reasons have not been received. Gilbert mentioned 60 days. There's a 60-day deadline. There's no rush. It can be filed on day 60. I know some applicants get stressed after a few weeks, but 60 days means 60 days. And the reason also that that's important is that, as Gilbert says, some applicants, some sponsors will also apply for submit an access to information or ATIP request for the notes. And the more time you have for that to be processed, the better. An extension of time is possible if necessary with a reasonable explanation. So, don't stress too much. It's best to get it in within the 60 days, but it's possible to file a judicial review after that as well. So then the visa office has to send the GCMS notes to the court as part of the judicial review process. Normally, that has also included the interview notes, but what we're finding, and this has just happened in the past year, is that some visa offices are not including interview notes, which is why, from my perspective, it's important for you as sponsors or as applicants and families to submit an ATIP request. It's fairly straightforward. It's something you could discuss amongst yourselves. I think it's important to submit those because what we're finding that since the visa offices are not sending, or some visa offices are not sending interview notes, we're finding that generally we're getting them through ATIP requests. And that's important because it helps provide a better or fuller picture of what actually happened and what was discussed. Now, Gilbert has talked about the process, at least that I use, which is to divide up this first part of a judicial review into two. And the first step is to file the judicial review. We get the officer's notes, and then we discuss with you, with the family, with the applicants, what the likelihood of success is and whether there's merits to proceeding. You'll see from the statistics later that at this point in the process, for the last 3 years of my statistics, 22 to 24, about 25% of applicants bail at this point because they don't think it's worthwhile, either for the cost or because the likelihood of success is too low. So that's one thing to note. The other thing to note is that we've also had some success at this early stage, at this first step. If the issues are really obvious, or as I've said here, very obvious, we've sometimes had success in getting the case settled already at the very early stage of the process. So it's important to note this kind of initial two-step process that Gilbert has talked about, because we can look at a case after getting the officer's reasons and then discuss the merits before moving on to the next step, which is you'll see what takes up the most work and costs the most. Now, the legal costs vary, and this is something I think that's very important to stress. You may get a quote for these initial steps, both to file the initial application, to start the process, and to file the application record. you may get a quote as low as $2,500 or $3,000, and it could be up to $8,000 and higher. So you need to be clear what you're paying for. And I know that RSTP, for example, has had a list of lawyers who will offer discounted prices, but that's an outdated list. I know some people I've talked to have surprised their names are still on it, but not only that, you need to check what the discounted price really is. Is it you're getting $8,000 reduced to $7,000, or is it $5,000 reduced to $4,000? Or what exactly? So it's an important consideration because there really is a large range of prices. So this is what I would call the second step. And this is the main part of a judicial review, in my view, because it's where we prepare the application record. And that's anywhere from 150 to 300 pages, maybe more, and includes all the relevant documents, the sponsorship application forms, any supporting documents that were submitted, the affidavits that we prepare, and the legal submission. And we will normally prepare an affidavit for one of the main applicants to explain the case from their perspective and to include any relevant comments about the interview process, to address any issues regarding procedural fairness, regarding credibility, regarding the assessment of the claim. Basically, at this point, they'll have seen, if we've got the interview notes, they'll have seen the interview notes, they'll be able to comment about them. I did not say that, or I did say this, or I said something else, it's not included, because these notes are all recorded from the officer's perspective, by the officer. It's an extremely unequal, or it's not a level playing field, but that's what we have. And so an affidavit from the applicant or one of the applicants helps to explain things from their perspective. So that's the heart of the matter. The application record will make or break your case. And again, as you'll see from the stats later on, most cases do not go beyond this stage. And in my experience, and again, I'm just looking at this 3-year period, 22 to 24, and it's post-COVID, and there are other factors related to that as well. But for my practice, about 80% of my cases are dealt with at this stage or earlier. So I think that's worth noting as well, not only in terms of how long the process takes, but also how you negotiate fees with lawyers. Many of you will have heard that the first step involves the court granting leave, and the second step involves leave being granted. It's helpful, but as I said, I've split up that first part into two, and now the second part, there's a third step after leave's been granted. What that essentially means is the judge has reviewed everything and says, I think there's serious issues. The case has merit. I'm going to schedule a hearing, and another judge will take a look and hear the case in person. Now, as I said, very few cases actually get to that point because they're settled beforehand. But there's still a possibility that even at this stage, they'll get settled before a hearing. And as my stats will show, 13% of my cases during that period went to a hearing. Half were granted, half were dismissed. So let's move to the main issues. I'm gonna look at 3 categories of issues: procedural fairness, and then the next slide will be credibility, and then the next slide will relate to the assessment of persecution. So procedural fairness, many of you probably understand or may understand what this is. The question is basically, did the officer do something unfair? For example, did the officer mention issues in the final assessment that were not actually discussed or mentioned during the interview? Or did the officer rely on something, usually a document of some sort, that was not disclosed? And we've got 2 examples. One is the issue of durable solution. So back in 2022-23, we had a cluster of about 6 cases from different sponsors and different groups of 5 that were all refused on the basis of durable solution in South Africa. And I'm assuming that some of you know what that means. Basically, the case is refused because the officer thinks the applicant has a durable solution in South Africa, and that usually, or actually always, is based on the fact that they have been granted asylum in South Africa. So it's a bit of a catch-22 for them, because especially with the groups of 5, they needed to show RSD for the G5 application, but then that RSD, the refugee status determination in South Africa, was being used by the visa officer to say you have a durable solution, and it's being refused on that basis. So the issue, the procedural fairness issue that arose in Pretoria amongst these cases was this. The officer, and there were, I think, 5 cases that were all decided by the same officer, and he made the same mistake in all of them. He basically said at the outset of the interview, okay, we're going to discuss your persecution in your country back home and the credibility of your case and durable solution. So he asked them about their case back home and why they're in danger, but he never asked them about durable solution in South Africa. And then in his reasons and in his decision, he refused because he said, I think you have a durable solution in South Africa. But he never raised that with them and never gave them the opportunity to say why they didn't, or provide any kind of reasons why they didn't. So it was a clear procedural fairness issue. We raised that with the government lawyer, and they agreed to set aside all those decisions. So that's one clear example. The other one, which is the issue of first information reports in Pakistan. Now, that's something else that I know a number of you have seen in the context of cases, especially from Pakistan, being dealt with by the visa office in Singapore. So a lot of applicants have submitted first information reports to support their case, to say somebody has brought a case against us, usually a blasphemy case against us in Pakistan. And then what the visa office has been doing is sending these off for assessment. And the risk assessment unit, the RAU in Islamabad of IRCC, is looking into these or assessing these cases. And what they've basically been saying is, we don't think they're legit. We think they're fraudulent. So they've got this sort of subplot going on, but they don't always raise the issue. Or when they do raise the issue with the applicants, it's during the interview. And what we've seen is it's often at the very end of the interview. So the question is whether this is a breach of procedural fairness or not. And one of the cases you'll see on our list at the end, the Iqbal case, a couple of years ago, we were successful with that case because the RAU had specifically gotten a couple of reports saying that the FIR was not legitimate. It was essentially, it related to another person with a different offense. And the visa officer gave no details of this to the Iqbal family, and the court agreed that that was a breach of procedural fairness. Now, the sequel to that story is it went back for redetermination and was refused again the second time. And what we're seeing now is that the visa offices are providing more information about these reports, but they're not divulging the reports. But what they are saying is, we don't think this FIR is genuine, and our assessment has shown it relates to somebody else and a different offense. But that's it. The question is, and this is still an issue that's before the courts, and we've got a couple of cases ongoing with this issue now. The question is, what is a reasonable notice of these issues? What's adequate notice? So that when the visa office and the risk assessment unit is doing these assessments, and they've done an assessment, for example, a year ago, and now you've got your interview tomorrow, and they don't say anything until the end of the interview, and said, oh, by the way, we've done this assessment, and we don't think this FIR is genuine. Do you have any comments or response? And it's like they're shocked, like they don't know. It's like they're blindsided by this. So this is the question now, what is reasonable notice in these situations? And one of the recent cases, or one of the ongoing cases, the government lawyer's response basically has been, well, if you need more time, they should have asked for it. And we know that it's easier said than done for applicants in these interview situations, but it's something for you to think about and to advise your applicants. Or actually, the better approach perhaps is think twice about submitting an FIR. Anyways, that's procedural fairness. Credibility, I think credibility issues arise basically in most cases. And in most cases, we find that the credibility conclusions are unreasonable. Now, I know that we've often thought historically that if there's a credibility finding, we're sunk, but that's not the case at all. In other words, do not let a negative credibility finding deter you, because when we dig deeper, we often find they don't hold up. So you'll see some of the issues here that we've found. You'll often see in a decision letter, there were numerous inconsistencies or numerous discrepancies, but there might be one. And there might be one that is not significant. It may relate to, whether something happened on February 5th or February 8th. But we could argue that it's not relevant or it's a minor or insignificant inconsistencies. And then you've got, there may not actually be any consistencies or contradictions. We have a case, and it might have been, it's just a recent one. The decision letter said this, and just bear with me because you have all these double negatives, as you may know. I am not satisfied that you are not inadmissible based on statements made at the resettlement interview and discrepancies with what was written on your application. Furthermore, when given multiple opportunities to respond, you failed to allay my concerns. These inconsistencies introduce credibility concerns, and because of that, blah, blah, blah. So that was a decision letter. When we got the officer's reasons and the interview notes, they all come by email. It's easy to do a word search. The first thing I did was did a word search of the GCMS notes, and not once did the word inconsistency or discrepancy arise. The only place it arose, or these two words arose, was in the decision letter. In other words, the officer did not raise any inconsistencies or discrepancies during the interview, nor did the officer even assess that in her reasons. So it comes up in the decision letter, and it's like, hold on, this is unreasonable. There are no discrepancies. There are no inconsistencies. So that's a pretty blatant example, but it's not unusual. And then you've got the other 2 points there. The last one, this often arises as well. I'm sure many of us have heard stories that we sort of raise our eyebrows and say, wow, how did that happen? But it does. And officers often will refuse a case because they say, I just don't think that's plausible. So the legal concept is that an officer cannot consider the plausibility of a story from their perspective, sitting here in coming from Canada, or even though they're sitting in Singapore or Pretoria or Islamabad or Beirut, they have to consider it from the perspective of the applicant. And from the perspective of the applicant, what's something that may seem implausible to us here in Canada or from a Canadian perspective may be plausible from their perspective. So that's often where an officer will get tripped up as well. Then the next slide, the failure to properly assess persecution. One of Gilbert's cases, we dealt with this, and it's again on our list of cases, the Dukuzeyesu case. Let me explain it this way, and you'll get a couple of examples here. An officer will often focus on one main applicant, perhaps a principal applicant. Maybe they'll only interview one or primarily interview one. But the mistake comes when there are valid reasons or grounds of persecution on behalf of some of the other applicants. And a classic example is gender-based persecution. If you have a family from Afghanistan, the female applicants will always have a claim that is distinct from the male family members. So 2 parts of this. One, you need to make sure that you add those details in the application forms. But more importantly, then the officer is also under an obligation to canvass all those issues as well. So the Dukuzeyesu case is a case where the officer neglected to consider the female applicant's claim. And so the government lawyer argued, well, she didn't properly present it or fully present it. But when you looked at the application forms, there were details there. And during the interview, she had also mentioned some specific things, and the officer neglected to consider that and focus solely on the male applicant. Another key mistake is that the officer does not properly consider the UNHCR status or refugee status conveyed by a country. Uganda, for example, will sometimes have granted refugee status to someone in the Horn of Africa from one of the, Eritrea or Ethiopia. And so there are a number of cases, including the Amanuel case that I've listed, where the court has specifically said one of the errors is the fact that the officer did not properly consider UNHCR status, which is an indication that a case has merit. Just in terms of some of the other considerations, as I mentioned, clarify costs beforehand. Some of the lawyers will quote one price for those first two steps that I've listed. You may want to canvass the option of trying to split that up so you can get a merit assessment before paying or proceeding with the application record. I think one of my main points now will be how to avoid refusals and judicial reviews. I really enjoy this work, but I don't need to be doing this. And I'd rather not be doing this if it means or meant that cases were accepted. Please, ensure details are consistent. Ensure that there are sufficient details, like if you've got female applicants who face gender-related persecution, make sure you mention something about that. So provide sufficient details about that. And then finally, make sure applicants are aware of the details and have reviewed the story. You would not believe the number of times we've gotten interview notes and reasons, and the officer will say in the course of the interview, "That's not what you said in your application forms." And the response is, "I didn't know what's in the forms. I didn't know what was in them." It happens more often than you'd think. So something simple, make sure applicants have reviewed the forms before they're submitted and have verified the details are correct. So last comment, here's some of the cases, recent cases that have gone to court and that we've gotten a decision. And I'll end with one comment before we go to the questions. I've been doing judicial reviews now of these overseas cases for 20 years. I saw some of my records I was looking up for this, and it was actually September 15th, 2005 that I filed my first one after leaving MCC and going back into law practice. So for 20 years, I've been doing this, and there's good news and bad news. The bad news is that in those 20 years, the decisions of visa officers have not improved. We see the same issues and the same unreasonable mistakes. The good news is that judicial reviews have been successful and continue to be successful. It's like a necessary evil. You wish it wasn't necessary, but at least the process works. Now I'll leave it at that.
Thank you so much to both of you, Gilbert and Tim. And everything you have shared was really insightful. And I've learned something new about, the ways sponsors can possibly handle the financial aspect when dealing with lawyers. But we do want to take time to hear from you, and maybe you have a case that was successful that you want to share with us, or maybe you have questions. So I just want to highlight a comment made that they were able to obtain GCMS notes through a Freedom of Information request with the PA's consent. And just below that, they have a case that is over 6 years old, stuck in admissibility. The PA had a second interview in October 2024. They applied twice for the GCMS notes, and specifically the notes from the second interview, but IRCC has chosen not to release those notes. So Tim, why is IRCC able to withhold sections of GCMS notes following an ATIP application?
Well, in some ways, they're two separate processes, and this is one of the dilemmas we face. And so up until recently, as I said, we've been getting the interview notes along with the officer's comments. So most of the GCMS, the relevant GCMS notes when we file a judicial review. But then recently, the interview notes have not been included by some visa offices, and we challenged this issue with the court. We took it to court and asked about it, and the judge said, "Well, no, the interview notes are not required as long as the officer's reasons are included." So what we've been finding, though, since then is that when sponsors or applicants put in an ATIP request for the GCMS notes, at least in the past 8 months, they've been getting them in time to include in the judicial review or the application record. So they may not come officially from the visa office, but they do come through the ATIP request. In terms of the other delays, I've seen that as well over the last number of years, and it's frustrating. And unfortunately, as I said, the ATIP process is not at all linked to judicial review process. But thankfully, at least for now, we have been getting responses through ATIP in a timely manner when it relates to an ongoing judicial review. But those other cases that with the delays, it's not really part of the judicial review process. It would have to be taken up as a separate issue.
Thank you for that, Tim. I guess it calls into question too, would there be a possibility there being differences in what's shared by IRCC based on who's making the request? So if it's coming from a legal representative, would they get different notes than, say, a private sponsor if they are making that request?
No. In fact, what I find is that if sponsors or applicants submit it, it'll usually get there faster than if I do.
Okay. Thank you for that.
And I see another question here too is from Rudy. We have not noticed differences between what comes through ATIP and what comes through the judicial review process. Well, I should say maybe a couple times there were some sections that were redacted or blacked out in the ATIP response that the GCMS notes from the visa office as part of the judicial review process did not black out or redact. But that's only happened in 1 or 2 cases that I recall. Otherwise, they would be the same.
Thank you for that. We have a couple of other sponsors sharing how long it's taken them. And I think it's worth the SAW Association maybe taking that as an issue forward through the NGO Government Committee to get an answer to that question, to raise that as an issue based on, even just comments in this one webinar. It seems like there's inconsistency in the length of time it takes.
Yes, mandamus, yes, that's definitely a possibility. I generally don't or haven't done them. I know a lot of lawyers do them and do them regularly. So it's definitely worth considering, depending on how long the delay is. I don't know if it'd be worth it for an ATIP request. It could be expensive just to get the notes, but if it's successful and it gets you what you want, that's worthwhile. But it relates to cases that are lingering or languishing rather for 3, 4, 5 years or longer.
Tim, can you please elaborate on the durable solution? A family I sponsored was declined because the wife, who is the main applicant, is Syrian and the husband Lebanese. It's worth noting that husband was born and raised in Syria. He owned a business and a house in Syria. He has a Lebanese passport through parents only, but no connections to the country whatsoever.
Yeah, we've seen this primarily arising amongst Syrian cases. And it's not just people who are either married to or have a link with someone who's Lebanese, but we're also finding that over the last number of years, and I know some of you have dealt with these issues, is Syrians who have Armenian heritage. And the visa office, after the bulk of the Syrians came and the program started winding down and there were still a lot of cases in process, and it's kind of like people lost interest and the visa office lost interest and the targets went down. It's like, okay, what are we going to do with all these cases? And they started refusing on the basis of durable solution. Like, for example, durable solution in Armenia, even though someone had never been there. It's one of those issues where legally, if you have access to a nationality and it's within your control to obtain the nationality, then you have to be able to show that either you can't, or you won't get it, or that you'll face persecution there. So basically, nationality laws say, and the way that the courts in Canada have interpreted it is that if it's within your power to apply and you could likely obtain it, then you've got to be able to respond to that and why you can't go. And just the fact that you've never been there isn't a sufficient response.
Thank you for that. We do have a question asking about highest refusals. Is there a particular nationality that you've noticed receives the highest number of refusals? And are there common reasons associated to that?
I haven't seen any trends in that regard. To be honest, what we find is, like, unlike the refugee system here in Canada, somebody arrives in Canada and the refugee board deals with their case. And the refugee board could deal with an unlimited number of cases. If people arrive and apply, the refugee board has to deal with it, and they'll deal with them all on the equal footing. But what happens with the overseas cases is that there are targets or quotas. And so each visa office has their targets or quotas, and we know that often there are a lot more applications than there are spots available. And so I think it inevitably becomes one of the factors. And it's not necessarily where they're from so much as capacity and when your case is processed. So, for example, on the issue of durable solution in South Africa, we know that a lot of the cases I've dealt with are Eritreans, Ethiopians, Rwandans, people from DRC who end up in South Africa. And we know that there are a lot of applications accepted by Pretoria, including those who have asylum status in South Africa. So we know that some people are coming to Canada and being accepted despite the fact they have asylum status in South Africa, whereas others are refused. And I also know that of the cases that I mentioned earlier, where there were some procedural fairness issues, the cases regarding durable solution in South Africa that where we've been successful and they've gone back for a second interview, some have been refused a second time and some have been accepted. I have no idea why. If you were to look at underlying factors, maybe somebody had a better documented case and could show that, they suffered worse from the xenophobia in South Africa. Maybe there were some other factors regarding their case, but really some of those decisions, it's hard to decipher what the rationale is, why some are accepted and some are refused.
Thanks, Tim. I just wanted to make a comment for those who had previously contacted RSTP to get a list of lawyers and support through the Refugee Sponsorship Support Program, the SSP. In 2025, RSTP no longer received funding to continue with that program. And so with our new contribution agreement, we aren't going to be continuing with that. So if you do have that list, it is actually outdated and you may want to look to other sources for locating lawyers. And maybe that would be something that the SAW Association could do for its members, is just have a discussion board or someplace where you can share comments about lawyers you've worked with before that have had reasonable rates. That might be an opportunity for sponsorship agreement holders. So moving on, another question, what happens if the officer didn't take notes during the interview?
Like for interview notes, this is such a frustrating part of the process. Generally, I haven't seen any cases, Abir, where they have not taken notes. I think what we find more is, are the notes accurate? When are they actually uploaded into GCMS, into the computer system? But I think it's helpful to note that there was a judge in a recent case in the last couple of years who basically said, and it was kind of the debate that was going on. It wasn't one of my cases, but it was a debate that was going on, kind of like not he said, she said, but it was like the applicant had submitted an affidavit saying, this is what happened, this is what was discussed during the interview. And the GCMS note said, no, this is what happened. But as I said earlier, it's all from the perspective of the visa officer. And so the judge acknowledge that the affidavit through the judicial review process is the opportunity for the applicant to put their case forward as to what happened. And so in that case, the visa officer did not submit an affidavit, disagreed with it. So the officer says, okay, I'm left with the applicant's affidavit and I have to take it at face value. So that's one part of the story. The other part of it is the judge saying, in this day and age, you would think that recordings would be possible. Like, why can't they be provided? In the same way that the Refugee Board provides recordings, in the same way this Zoom webinar is recorded. Why can't these interviews be recorded? Because we know that these officers are very clear, you cannot bring a phone here, you cannot record this. And it's really unfair, I think. And I do think that that's something else that needs to be pursued in future, both from your side and from our side, perhaps, to keep pushing back to say there's got to be some kind of a recording available, because so often issues arise with the interpreters or in terms of how someone's response is conveyed by the interpreter or how it's interpreted by the visa officer, or an applicant will say, I didn't say it like that. I didn't say that. And yes, that's what the GCMS notes say. So it's definitely something that needs work. It's an area of this that needs work. I do think the recording should be available. I think what we need to be clear about is that after judicial review starts, basically cannot introduce new evidence. Now, what we've been able to do is include some country-related reports just to show what the conditions have been like, to be able to assess an officer's decision, whether it makes sense in light of the actual country conditions. So we've been able to submit those, but anything else like a UNHCR file or report, you have to get that up front. That has to be something that the applicants are accessing. If they think it's important, that they have to access up front.
I would like to comment a little bit on this unfairness pertaining to the fact that interviews are not recorded overseas. Knowing that this advocacy for getting these interviews recorded might take a long time or never happen. That's why, in our experience, we have really given a lot of importance to asking the PA via the co-sponsor what happened in the interview room. Ask them if they have any comments or about the behavior of the officer. If they might know where the refusal originated. And if this is not in the interview notes, we will just make it as a statement and put in writing and just hand them over to our lawyer, and probably he will use that. I think, giving importance to what the principal applicant has heard and how he felt or she felt is very important to cover that unfairness that is there, that because the interview notes are not exhaustive of what happened, and major parts of what happened in the interview room might have forgotten. Thank you.
Thank you so much, Gilbert. I see we have a couple of hands raised. I'm going to come to those. Before we change the topic, Tim, I think there's a related question that might be helpful that you could answer. Up until when can new evidence and documents be submitted for a particular case?
Up until a decision is made. And so if people think some things went awry during the interview, it's possible to submit documents afterwards. And I know some SAWs or some sponsors have done that. Like I said earlier, regarding the whole issue of procedural fairness and first information reports, the government lawyer in one of our ongoing cases suggests that applicants actually ask, when that issue is raised during the interview, ask for an opportunity to look into that and provide a response. And these officers may not provide it, but if you ask and it's refused, at least there's some other grounds then to dispute the decision. So I think it's something to think about, that, if something arises during the interview, advise the applicants that, if they're surprised by something that's raised, ask for more time to respond.
Thank you. And a related question is it possible to withdraw a document, for example, the FIR, once it's been submitted as part of the original application?
My advice at this point would be, given what's happening there in Singapore in particular, just think twice before they're submitted in the first place. I think otherwise, if it's already there, you may want to take some steps to try and have it independently verified. And from my perspective, it needs to be someone who's in Pakistan, who's able to go and actually trace these back to the source to see if a police station or if a court has a document and can verify that. So, and I know there's also another question related to that, which is, why is there such an emphasis on the FIRs, and why does that sort of sink the whole case? Mm-hmm. What about the other evidence? And it's one of those things, going back to the credibility discussion, which is basically, when is one particular credibility issue sufficient to sink the whole case? And when is it sort of, not necessarily minor, but insignificant enough that it can be overlooked? And we have, there are cases from the federal court which basically say, if you've got a particular refugee profile that is in danger, for example, let's say a female from Afghanistan, then certain other credibility factors can be overlooked, or your overall risk profile sort of trumps or overcomes the credibility issue related to a particular document. Now, with respect to Christians in particular from Pakistan, they are a risk profile, but it seems that the visa offices are not, saying it's automatically a risk profile. Like, there's got to be more. So you've got to still test the credibility of the case and what actually happened. And so then you've got an FIR, which is brought into the balance in terms of a visa officer assessing, is this sufficient? I do, however, agree that it seems unreasonable to refuse a case based on the submission of a document that someone thinks, or they're not knowingly submitting a fraudulent document. They think it's legit. They've gotten it and they submit it. That's being considered sufficient to sink a case. I think it's unfortunate, but it's something to still keep in mind and keep working at, in terms of pushing your case and saying, well, yes, there are other reasons, or someone prepare an applicant in that situation to say, what about, there's X, Y, Z, there are all these other factors in my case apart from that.
Yeah, I think I can respond to that. We do know that IRCC has a huge backlog of applications right now, and largely in part due to COVID, truthfully, that added to an already huge number of applications in the system. And that's another reason why they put a pause on application submissions for groups of 5 and community sponsors. But I wonder if maybe your question is there anything legally that can be done because of these lengthy delays? And in particular, I'm thinking about, the sponsorship agreement that sponsorship agreement holders have, where it states that, IRCC will commit to these particular timelines for processing. Any thoughts on that, Tim?
Is the delay like with Rocco before the case gets to the visa office, or is it after it gets to the visa office? We'd have to look at the reasons, ultimately what the decision you get, and what the reasons are, to be able to assess or what the issue has been. So I think each case sort of needs to be looked at differently or assessed differently in that situation to see what the reasons for that final refusal might have been when it's unexpected, or it hasn't even been an interview. Well, why don't you send it to Serena, and then we can possibly discuss later.
Yeah, sounds good. And we'll connect with you first. We'll get your RSTP trainer connected with you to go through the letter with you to see if it's the letter from Rocco or whether it's from the visa office. and we can advise you whether it's a good idea to consult with a legal professional or not. We do have some more questions. Has a case approved for urgent processing and the visa office in question has been able to honor that and offer an interview quickly. But the interview didn't go well. The applicant reported that the visa officer had plausibility concerns, and we expect to get a negative decision. Meanwhile, the applicant continues to need to relocate constantly due to security concerns. Obviously, as judicial reviews process, applicants continue to wait in sometimes very difficult circumstances. In cases where there is a risk to an applicant's security that has been recognized by IRCC and the visa officer, is there a way to expedite the judicial review process?
It was years ago that I know what one case from years ago that was expedited because of some urgent issues. I think that would have to be raised to a particular level. I haven't seen it recently because I know that it's something that a lot of people would think that they're in that situation. I hear it constantly. So it's something that, like, what takes sort of the usual kind of dangerous situation into sort of the next level danger that needs to be expedited. At this point, I don't know of any particular situations, but perhaps with the unique fact situation that could be done.
And question regarding the fraudulent FIRs. Is there any room for an argument to be made for consideration of the whole story apart from the FIR, especially given the fact that the documents were never submitted with the intent to deceive?
Yeah, I tried to address that earlier as well, that you'd like to think, and the court has said in some cases, that the decision is unreasonable if the visa officer neglects to consider the overall risk profile and some of the other evidence. And so I think it's harder to do in an individual case, like in the context of an interview or even a post-interview submissions. You could try it, and sponsors could try it if it's come up at the interview to say, look, please consider all the other factors or all the other evidence, or maybe there's new evidence or additional evidence. But I do think that sort of looking at the FIRs and, even trying to come up with like your own independent assessment of it. Like we tried that once a couple of years ago with the SAW. We found some contacts in Pakistan who pursued it. So before deciding whether to continue with the judicial review, the SAWs wanted to know, okay, let's try to assess this FIR. And through some independent channels that we found in Pakistan, they went and checked and confirmed it was not legitimate, it was not genuine. And the SAW said, okay, that's it. We're not going to continue. Setting up some of those channels to find ways and places back there to verify them, I think, is important.
Thank you so much, Tim. I'm going to take the last question. I know we could go on all night because this is a topic that SAWs and sponsors are really interested in.
Well, I'd like to get Gilbert's response in a moment about the case that he mentioned that they discontinued and then they reapplied, because I also have one example of a case that actually went all the way to a court hearing. And after the court hearing, the court dismissed the judicial review and the family submitted a new application. And what they did was, rather than focusing on, I think in that case, rather than the male applicant being the primary applicant, it was the female who became the primary applicant, and it was a whole story related to her particular danger. And I think that's what they ended up doing in their new application, and the case was eventually accepted. And that worked. And so you never know, and maybe Gilbert can comment on the case that they submitted.
Yes, thank you. The second interview, I think, is different if it is a second interview after judicial review, because that second interview is decided by the federal court that quashes the first decision and send the case back to the visa office. And also, in that case, by law, the refugee has to be interviewed by a different officer. It's different from from the example I have given. That example was about a case that has been discontinued. After the first step of the judicial review, with the help of the lawyer, we discussed that and we found that there are no enough chances to be successful with judicial review. And then the case was discontinued. Now, the advantage we had from that judicial review process was that we studied this case with the lawyer when we knew what the problem was with the first interview or with the first personal story. I reapplied for the same family, but the case was much stronger and it was accepted. I don't know if there is anything that stops from an applicant to reapply. There is nothing that stops that. So if you have received a refusal and you believe that you are a refugee and the SAR believes in the case, I don't see anything that will stop you from reapplying. And my case was successful at the second interview.
Thank you so much. I want to express my deepest gratitude to Gilbert and Tim for giving us your time this evening to share these success stories. Those percentages are a lot higher than I would have expected they would be for success for judicial review. And I want to thank my colleague for assisting me in the background with the technical things. And I also want to thank each and every one of you sponsors for joining us this evening.